Good morning. Welcome to today's live webinar on the updated standard form of real estate contract. I'm Christian Sluter, a member of the Risk Management Committee. Today's webinar will provide an overview of the changes that have been made to our new statewide contract. We have New Jersey Realtors General Counsel Barry Goodman here with us, who will be discussing the changes and answering your questions. This webinar is being recorded and will be available on NJRealtor.com so that you may refer back to it at a later date or watch it at nighttime. We will try to get to as many questions as possible. When you submit your question, we ask that you please include the contract section and/or line number that you are referring to so that we may provide the most accurate responses.
Let's just a couple of preliminaries before we start going through the contract itself. First of all, the new statewide contract, it truly is a statewide contract. It's in effect. It's already up at NJRealtor.com. You can use it, and hopefully you are using it already. But just so that you're aware, the old Form 118 sales contract that New Jersey Realtors had is still up and available if you want to continue to use it for a little while. It will be available until December the 10th, which is the end of the Tri-State Convention. As soon as the convention ends, the old Form 118, the old contract, is going to be taken down and will not be available anymore. The old contract has been made TRID compliant with the new rules that went into effect last Saturday, October 3, the Consumer Financial Protection Bureau rules. We added in a section to deal with that, but I'm going to tell you, as you will see, the new statewide contract provides so many additional protections for buyers and sellers and you, that I strongly recommend you immediately start using the new statewide contract. Do not, use the old Form 118 forever. Switch over because it's a better contract for everybody that's involved. Also, I would just want you to know that in addition to revising the old contract and creating a new statewide sales contract, New Jersey Realtors also updated the short sales addendum and the new construction rider to conform to the issues that we're now going to discuss on the new statewide contract. Just so you're aware, those are new forms that are up there too. Now, let's start going through the contract, and I want to emphasize to you that I'm only going to hit the highlights of the new contract, the major changes. There are wording changes throughout that I just cannot deal with in the scope of a webinar. So I'm going to hit the highlights for you, and I encourage all of you, take the time to read through the new statewide contract so that you feel very comfortable with it when you're using it. And you'll see the different nuances. I get a lot of the questions that have already been submitted deal with issues that were in the old contract and haven't even been changed, which tells me a lot of people haven't read the sales contract in quite a while. So I strongly advise you read the new statewide contract. Take notes now. Hopefully you have a copy of it in front of you. Take notes as we go through it, and I'll highlight the major issues. Okay, without further introduction, let's start with the Opinion 26 notice. We made just a very minor change to the Opinion 26 notice, which, as you know, is the cover page to the sales contract. It's required by the New Jersey Supreme Court, and so that you are not committing the unauthorized practice of law. It allows you to prepare a contract for other people. Down bottom of the Opinion 26 notice, you will see that we added in a signature line for listing broker. All too often, there's a question, what happens? What does the listing broker sign? So we just added in a line for the listing broker to sign. Usually it's the selling broker who is preparing the Opinion 26 notice when they prepare the offer. And so there's a place for the listing broker to sign when the sellers sign the Opinion 26 notice. We also, and let me just point out, it says selling broker. A lot of people have asked me, Barry, nobody really uses those terms. It's really buyer's agent, and I understand that. But the Supreme Court created this form, and I want to make as few changes to it as possible. Certainly, I don't want to change any wording that the Supreme Court included, and they included the phrase selling broker to denote the buyer's agent here. So we left that alone, but let's all be clear, that's the buyer's agent. Also, people ask, well, Barry, who's supposed to sign it? Does the broker have to sign? Can the agent sign? Custom and practice has always been that the agent signs, especially the buyer's agent will sign when the buyer's agent prepares the offer and has the buyer sign the opinion 26 notice. I think that continues. The Supreme Court used the term broker, but I think they really meant for it to be the agent. So the custom and practice as it has been should continue. We've also included down bottom prepared by, so you should insert the name there. We did that because we didn't want there to be confusion, because in section 1, it specifically states, as a real estate broker, I represent, and then you check off the box, the seller, not the buyer, not the seller. So it would be unclear if you didn't know who prepared it. I've been asked, well, what if the contract is actually prepared by an assistant who's unlicensed? Somebody who's licensed has to be responsible for the preparation of the contract. So the prepared by has to be a licensed individual, even if the licensed individual has unlicensed assistants who do paperwork for the agent. It's the agent, the licensed agent, who must sign prepared by. An unlicensed person should not be signing that. Let's move on to the next page. The first page of the contract itself. You'll see it's a little bit different. At the top, of course, is the language that's required by the Supreme Court under the attorney review decision about a person's right to have an attorney review the contract within 3 business days. The Supreme Court requires that language right at the top of the contract, so we certainly are not going to change that. We cannot change that. But right below that, we added in a table of contents. We took it from the back of the contract. We thought it just made more sense to have the table of contents right up front. Easier for you to find things, easier for the buyer and seller to find things this way. Just thought it was the best place to have it, so we changed that around. The next section, section 1, is essentially the same. We made some minor tweaks, changed the title of it, parties and property description, but it's essentially the same as it was before. Down bottom on the first page, we added in a section that kind of captures the financial aspect of the transaction, the purchase price. And we included the total purchase price and then broke down how that's going to be paid. The initial deposit, initial deposit, additional deposit, mortgage, and the balance of the purchase price that has to be tendered at the closing. So this way, right on the first page, you have the parties, the property, and the purchase price and how it's broken down in a convenient form for everybody to use. Just thought that made sense. Now, moving over to the next page, section 3, manner of payment. You'll see an initial deposit, we've reworded it. The old sales contract specifically provided that there was a representation by the buyer's agent that any amount that was filled in for the initial deposit was there. It said on signing this contract, they have the initial deposit. And what was happening is that very often the buyer's agent didn't have the deposit. Maybe it was an electronic transaction and the buyer was in Toronto or Seattle or wherever, and you want to get that contract in, the offer in really fast. And the buyer says, I'll FedEx you the initial deposit. Well, the problem is you've made a representation in the old contract that you have it on signing this agreement, which you did not. And it's a misrepresentation, and the Real Estate Commission started to go into offices and look for that. I started to counsel people, look, in that situation, put in $0 then for the initial deposit because you don't have it. Bottom line is, now we've changed that so as to say that the initial deposit is to be paid by buyer to, and it says on or before X date. So you fill in a date when the initial deposit has to be made. And we've also added in, it used to be that it would be paid to, it said either listing broker or participating broker. Well, we've added buyer's attorney as an option, title company as an option, and other as an option. Because more and more brokers don't want to be responsible for holding the deposit money, and they want the attorney to hold it, or the title company in South Jersey. And I suspect that going forward, there'll be more title company closings in North Jersey as a result of the new Consumer Financial Protection Bureau rules that went into effect on October 3. So we've included that, and just in case there's somebody else, whether it be the seller's attorney, there's an agreement for some reason for the seller's attorney to handle, some other party to handle the initial deposit, we've included a spot for other. So that way I think we are covered. And then moving down, and once again, I'm not going to touch on everything because it's too much for the scope of this webinar. But I do want to point out in section D, in the middle of this section, you'll see language concerning the attorney review period. It says within 10 calendar days after the attorney review period is completed, and it continues on. And let me read the whole thing. Or if this contract is timely disapproved by an attorney as provided in the attorney review section of this contract. So the timing is tied to the attorney review period, or when final agreement is reached after attorney review. In the old contract, it's a subtle difference, but it's an important one. In the old contract, it said within 10 calendar days after attorney review. Well, technically, as most of you know, attorney review can be the full 3 business days, or it can end when the attorney for one of the parties sends a notice of disapproval. And it made no sense to say after attorney review, because if attorney review ended when the contract was disapproved and there is no contract, why would somebody have to deal with a mortgage contingency at that point, or inspections and other items that were in the contract? So we changed the language to be more correct, because it's after attorney review is completed or after the parties agree upon the terms of the contract. That's when the time frame should start, and that's what it now reflects. Moving down to the paragraph starting, the written mortgage commitment must be delivered to seller's agent. This previously in the old contract said that if the mortgage commitment was not timely obtained by the buyer, either the buyer or the seller could void the contract. We've changed it to give a little bit more wiggle room there to allow an additional period. And so it says that it shall automatically be extended for a period not to exceed blank calendar days, and you're going to have to fill in blank calendar days. That's a decision when the offer is made for the buyer to make, and you can discuss it with the buyer. You could fill in 10 days, 14 days, 20 days, whatever is appropriate. And the seller may say, no, 0 days. I want certainty. I want to know when you're going to get it. So I don't want any additional time if the buyer can't get a mortgage. So that could be the subject of negotiation, but you're going to have to fill in a number of days, to try to keep the deal alive. We did this because we felt it's important to try, if the buyer is acting in good faith and there's just some delay that arises, especially with these new rules that have come into effect under the Consumer Financial Protection Bureau. If there's any confusion, we wanted to have a little additional time built in here, and that's why we've included this. Moving down to section F, we added in FHA VA loans if it's applicable. Now, that used to have to be an addendum, but here, and it still will be, there still will be an amendatory clause and certificate attaching to it, but this kind of highlights it. And you'll see right here it says applicable, not applicable, which just got highlighted. Throughout the new statewide contract, we've included applicable, not applicable to various sections. So that way if it's applicable, then you got to deal with that section. If you check not applicable, you can move right by that section and you don't have to deal with it. But you're now going to have to check that off to focus on it. We tried to help you to focus on it by putting in applicable and not applicable throughout where it would make sense. Moving down to section 5. Gotten a number of, buyer's property sale contingency. This used to have to be an addendum. And so let's put it right in the contract, because overwhelming majority of the time, the buyer has to sell a property in order to move forward with the purchase of a property. So let's include that right here. Let's lay out exactly what has to happen. If the property is already subject to a contract, the contract has to be provided to the broker and the seller. If it's not subject to a contract, then the buyer agrees to list it with a licensed broker within the applicable time. And there's a provision in terms of the seller being able to continue to market the property and what happens if another offer comes in. It's all laid out right here. I'm not going to go through every detail of it. Read it, and I think it works. There's also a paragraph at the end of section 5 that deals with the new rule, the Consumer Financial Protection Bureau rule, that if the closing on the sale of buyer's property has to be delayed, either because the lender does not timely provide documents through no fault of the buyer, or for 3 business days because of the change of terms as required by the Consumer Financial Protection Bureau, the closing with seller shall be delayed to allow buyer to close on buyer's property before the closing. This deals with the issue of, back-to-back closings. And what happens if the first closing on the buyer's property, buyer's sale of the property, is delayed because of the new rules that just went into effect, or through no fault of the buyer, and the buyer then doesn't have the money to go forward with the next closing, which is scheduled right after that closing. So there's an agreement now that if that happens, both closings will be put off. So that's one of those TRID compliance issues that we've included. Okay, moving down to section 9, dates and times for performance. What we've included here is time of the essence for the dates that are in the contract. Now, I know a lot of people in the North are a little leery of time of the essence. I can tell you that time of the essence has been the practice in South Jersey. It's the practice around most of the rest of the country. And it seems to work really well. And so we discussed it and we said, let's include time of the essence. There may be some attorneys during attorney review who are going to remove time of the essence because they don't want to be bound by the dates in the contract. And certainly that's something that can be agreed upon during attorney review. But the bottom line is time of the essence seems to work around the rest of the country and in South Jersey. So we've included it so that there's certainty for the buyer and the seller, as well as you, as to the dates that are in the contract. Now, we've once again included the same kind of language as an exception in this section if the closing has to be delayed as a result of a lender not timely providing documents, or because of the requirement that a closing be delayed for 3 business days under the new Consumer Financial Protection Bureau rules. As most of you know, under the new rules that went into effect on October 3, there are only 3 reasons that the closing must be delayed. And they all deal with a change in the terms of the loan product that the lender is providing to the consumer. If the lender increases the interest rate by more than 1/8%, it has to be delayed for 3 business days. If the lender changes the loan product from, let's say, a fixed rate to a variable rate mortgage, the closing has to be delayed for 3 business days. Or if the lender adds a prepayment penalty, it has to be delayed for 3 business days. Those are the only reasons. If there are any other changes at the closing, maybe adjustments because something was found during a walkthrough, that does not require that the closing be delayed. And the closing typically should not be delayed. It's handled the same way as closings are handled now. No different. So I want to end any confusion that might be out there in terms of delays in terms of the closing. So there might be some delays, but it's not, there are only 3 reasons that the delay will be required. And that's the key thing. And one thing you'll notice throughout, sometimes in South Jersey we refer to the closing as a settlement. We've tried to keep uniform language in this contract, so we refer to it as closing throughout the contract. Those of you who are used to using the word settlement, hopefully it's not going to be a big adjustment for you to start calling it a closing instead of a settlement.
Barry, we have a question with reference to line 80. Do you have any recommendation for the closing date extension days based on the new rule timelines?
The answer is that I would be generous in terms of the extension date. I suspect that over the first 2-3 months, maybe even 4 months that the new rules are in effect, there are going to be some delays because people aren't going to understand the new rules. So in the beginning, the extension, I'd say add on 2 weeks, add on 20 days, something of that magnitude, which can probably be even, and that's, I think, a reasonable period of time. But I suspect that after people get used to the new CFPB rules that just went into effect, you're not going to have delays. And the same would be true in terms of the closing date in Section 9. I would say be generous in terms of a closing date. Add on another 3 weeks in the beginning or so. so that way, if there is any issue in terms of closing because of the new rules that went into effect, there's a little bit more time built in to deal with it.
Can you explain the 3 reasons for the 3-day delay?
Well, as I said, they're built into the new Consumer Financial Protection Bureau rules. Those, if there's a change in the loan product, CFPB said, you know what, the consumer should be protected and should have some time to think about it. The new rules that went into effect are really to protect consumers. For those of you who are not familiar with the new rules, and I don't want this to be a seminar on the new rules, but what happens is that when the consumer, the buyer, submits a loan application, they have 3 business days, the lender has 3 business days in order to reply. Once the lender replies, the borrower then will have 7 business days to decide whether or not to take the loan. And then you go to the closing documents. The closing documents have to be in the hands of the consumer 3 business days before the closing. That's so that the consumer can have a chance to look at the information instead of, as is true under the old practice until last Saturday, the consumer would go to the closing and for the first time see the closing documents and with their eyes glazed over and not really understanding what's happening, and just they'll start signing. This way they'll have at least 3 business days to look at the closing documents, digest it, ask whatever questions they have of the closing documents. And the rules provide that if there is one of those 3 things changes in the loan product, the consumer should have a little bit of time to think about it. So that's why there's then the 3 business day delay at that point. So hey, do I really want to go forward if they're going to change the loan product, which hopefully is something that was discussed with the buyer, or if they're increasing the interest rate by more than 8% or adding a prepayment penalty, I may not want to go forward with this loan.
How does the time of the essence language in the contract change from the way things are currently or were before the 3rd?
I think there's going to really be very little change because of time of the essence. It's just that the dates that are fixed in the contract are the dates that have to be adhered to. And as we'll discuss later on, we're going to recommend that you use a timeline to keep track of the various dates in the contract, but I'll deal with that later. It's really not going to change very much at all because the contract provisions, unless they're changed during attorney review, should have been met even if there was no time of the essence provision. But now it just, it creates a little more certainty in that regard.
Thank you.
Okay, good questions. Thank you. Okay, moving on to Section 10, the Certificate of Occupancy and Zoning Compliance. I just want to point out that in the old sales contract, the seller agreed to pay to bring it into compliance, the property into compliance before the closing. There was no cap, no limit on the cost to the seller in terms of bringing it into compliance. Gave the seller no option to void the contract at that point. And it could, who knows what it would have cost the seller, could have been $25,000, $50,000, $75,000. It might have been something major that was discovered. We've now included a cap as to how much the seller has to spend in order to bring it into compliance. If it exceeds the cap, the buyer has the option to pay the excess. The parties can try to reach agreement as to how to handle the excess, maybe divide the cost of the excess amount. And if they can't reach agreement on it beyond that excess, then there's the right to void the contract. I will tell you that, this is a provision that is fairly standard around the country to cap the expense to bring it into compliance. I just personally had an experience in Florida where I asked the realtor, how much is normally put in there as an amount? And he said to me, typically we put in 1.5% of the purchase price as the number. He said in a hot market where it's really competitive bidding, we might put in 0 because we don't want to upset the apple cart. We put in 1.5% here of the purchase price. Seller came back and said, you know what, we want to cap it at $2,000. And we wound up negotiating a number in the middle. And that was the process. So you have to talk to your buyer about how much is a reasonable amount to include in this type of a provision. Okay, next, section 11. We've added in a section which had to be an addendum before, and you'll notice a lot of the things that used to be addenda, we've added into the contract just so we limit the number of things you have to attach. And this is one of them. If it's a condominium, homeowners association is involved, once again, it's applicable, not applicable. If it's not applicable, just check that box and move on. But if it's applicable, then documents have to be provided by the buyer, by the seller, sorry, to the buyer, so that the buyer can make an informed decision about the property. Also, assessments have to be disclosed. If the seller is aware of an assessment that's about to happen, there's discussion about a potential lawsuit or something like that, or a major repair to roadways in the development or the clubhouse, and the seller's aware of those discussions, it has to be disclosed, because that's important information for the buyer to have in terms of whether or not they want to put in an offer on this property, and if so, how much they want to offer. So all of that now is laid out in this section, so the buyer will have that information right up front. Some people have asked, well, what if the seller doesn't have a copy of the current rules, regulations, and bylaws to provide to the buyer? Well, I suggest when you take the listing, you should arrange to get those documents right away so they're available to potential buyers and can be provided to them. It makes no sense for individual buyers to have to go and get those documents, which can be a hassle. And many associations charge to get those documents. So it makes no sense for every individual buyer to have to incur that fee to pay for those documents. The seller should just do it once and it's then available.
Barry, one of the questions we have is that the documents that you're talking about are expensive for a seller. Why should they provide it to potential buyers ahead of time when they don't know how interested the party might be?
Certainly, if a seller or a listing agent, can make that decision. If somebody's just casually looking at the house and not really interested, maybe you don't provide it because the cost of the seller copying it can be an expense. So you can make that decision. But the bottom line is, if somebody appears to be a legitimate prospective buyer, they should have this information before they make the offer, and it should be provided to them. So discretion can be used in that regard, as far as I'm concerned. Okay, then moving on to, let's see, there's really nothing on the rest of this page that I think we need to go over. Let's move over to the next page, and I think possession, occupancy, and tenancies is pretty much the same, except we've added that copy of all leases have to be provided by the seller to the buyer. Once again, because that's very relevant in terms of the buyer's decision how much to offer. They want to make sure that those leases are in place and how long those leases are in effect. Section 15, the only thing we added is that the seller is going to supply to the buyer a validated certificate of registration and a certificate of inspection that's been issued by the DCA. Once again, that's something that should be provided anyway, but we figured let's just state it so that there's no question involved there. Moving down to section 16, lead-based paint, we added in section B, lead warning statement. This is something that's actually required by federal law to be provided to the buyer. So we said, let's just add it right into the contract so that the buyer has it. I don't know how many of you have been providing this warning, but bottom line is it's now there. You don't have to think about it. Let me be clear about something, though. This lead warning statement does not replace the addendum with regard to lead-based paint that you must still provide, because that addendum includes disclosures by the seller as to any lead-based paint issues that the seller is aware of, any remediation that's taken place. So you still have to use the addendum, the lead-based paint addendum, if the property was built prior to 1978. Okay, we can move past section 17. Is essentially the same as it's been, so I'm not going to deal with that. And we continue, there's really no major changes on page 8. And you'll see as we go through, we've actually reordered the different sections to try to group things like inspections and such together, so it made a little bit more sense. At least it made more sense to the Risk Management Committee, I'll say that. Okay, moving down to section F on page 9.
Barry, let me interrupt you for a
Sure.
second. We have a question. Whose responsibility is it to provide the lead disclosure?
The lead disclosure has to be provided by the seller and the seller's agent, the listing agent. And it has to be signed by the seller prior to the offer. Very often what happens is that an offer comes in and the lead-based paint addendum is signed by the buyer at that point and not signed by the seller. You got a problem if the seller signs, it's dated after the buyer signs. The seller has to sign first. Okay, so that's something that should be provided right up front. There are a number of things that are in this contract that should be provided right up front when you have a real buyer that's there. You know, when you get the call from a buyer's agent, I'm bringing in an offer, you say, well, let's make sure you have all the applicable documents. And you go through what documents you need to provide. You know, whether they're condo homeowners association documents, leases, lead-based paint, disclosure. So all of those should be provided right up front.
So to be clear, if the home is built after 1978, we do not have to use the addendum?
That is absolutely correct.
Okay, and you don't have to, do you have to provide the lead-based paint booklet any longer?
You should provide the booklet, if it's built prior to 1978.
Okay. Why did they take the options of selecting the time frame for inspection? 10 days does not work for second homes.
I'm not sure which section you're talking about.
If you scroll back up, it's where we, right, the first one's, hold on.
Well, let me just say generally in terms of, the inspection periods, because there are so many different sections that the risk management committee, dealt with in trying to find, a happy median in terms of the number of days to include. Some of the provisions, we actually used some provisions from the Burlington-Camden County Association of Realtors contract that, worked well for them. Some of the days we decided there were fairly standard numbers that typically were included in the contract, and we decided to insert them. The bottom line is that the parties always can change the number of days. If there's an issue in terms of the number of days, they can agree to change days. Attorneys certainly can change the number of days during attorney review. But there are certain areas that we just made a decision that typically there was this is the number of days that was, filled in more often than not. So let's try to lessen the number of things where you had to fill in a number. So you'll see some of these items, I don't want to say it's arbitrarily picked a number because it was based upon the consensus of the brokers and salespeople who worked on this contract. And I will tell you, they worked hard on it. We had representatives from North Jersey, Central Jersey, South Jersey, the Shore area, and collectively we decided on certain timeframes that made sense.
Is time of the essence for all of the dates?
The answer is yes. Time of the essence is for all of the dates in the contract. Okay. Moving right along then. Let's move down to section 23, the air safety and zoning notice. Now, this section we included really more for information than anything else, so that buyers would know that there's an issue with regard to the Air Safety and Zoning Act. If they were buying a property in one of the municipalities that's listed. We actually created a list. There was no master list that we could find. The New Jersey Department of Transportation oversees this act and did not have a list. So we created a list for information only. And the act itself specifies that if a property is in an air safety and zoning area, that not only must the seller, but also the broker representing the seller, the listing agent, must advise the buyer that the property is in an air safety and an airport safety zone. Now, what's an airport safety zone? An air safety zone? It's where the planes take off and where they land. It's the runway. What areas are affected by the runway? It's not where the airport is located necessarily, because sometimes the neighboring municipality might be affected. So we included the list as best we could But quite frankly, it's unclear if this is 100% accurate. So we've added in qualifying language, a disclaimer in there. This is for information only. And also, just so that you know, your obligation to provide this information to buyers is actually now incorporated into the Offsite Disclosure Act, Section 21. So we specified that. We actually changed the language in this section a little bit. We tweaked it recently just to make it very clear that this is for information only and that your obligation to disclose is taken care of by the provision that's in number 21, section 21 of the contract concerning off-site conditions. But this list is now here, so it's kind of alerts the buyer, hey, if you're buying property in one of these municipalities, you really should contact the clerk just to make sure there's no limitation. And the limitation typically is buildings are limited in terms of how high they can be built. You can't build towers. You can't have trees that are too high because it might affect the runway. It might affect the landings and the takeoffs. So this is here for information only. I want to be real clear about that. And one other thing I just want to refer to, because I get this question up. Barry, I'm looking at this list. It doesn't have Newark on it, Atlantic City, and we have, Newark Liberty Airport. We have Atlantic City International. There are a number of airports in New Jersey that are not governed by the NJ DOT and therefore not subject to this act or the Off-Site Disclosure Act. And I'm just going to quickly read them so that you know what they are for your information, but they're not within the purview of this act. The Essex County Airport, the Linden Airport, Newark Liberty Airport, Teterboro Airport, Little Ferry Seaplane Base, Atlantic City International, McGuire Air Force Base, Lakehurst. Some of these are governed by the Port Authority, others are military installations, but the bottom line is they don't fall within the act, and that's why they're not listed there. Okay, let's move on.
Barry, are agents only required to point out the town under Section 23 and advise the buyer to contact the proper associations for further details?
Actually, let me be really clear about this, because under Section 23, your obligation is satisfied by the fact that we have the off-site conditions disclosure in Section 21. You don't have any obligation to point out the air safety and zoning, issue to buyers, as long as that notification of off-site conditions is in the contract, which it is. So that's why we have tried to clearly state here, this is for information only. It doesn't create an obligation on your part or on the seller's part. It's just, hey, if a seller sees that a municipality is listed here, the bell should go off that they should be contacting the municipality, but you don't have an obligation. This is provided for information only.
Thank you.
Let's move over to Section 33, Broker's Information and Commission. There are two changes that I want to point out here, two major changes. In the paragraph, you see the last sentence, it says, the commission shall be paid upon the purchase price set forth in Section 2 and shall include any amounts allocated to, among other things, furniture and fixtures. Now, I'm going to be candid. We included this sentence to try to protect you in terms of your commission, because with the mansion tax, a tax on any property is $1 million or more, what we've seen is that, let's say the property, the real purchase price is $1.1 million. And then all of a sudden, the attorneys decide, well, let's allocate $150,000 to furniture, fixtures, or something else. So they lower the purchase price to below $1 million, to $950,000 in this example, so as to avoid the mansion tax. Well, we all know the real purchase price is $1.1 million. I think that it's improper to do what they're doing, but I'm not the one who's going to report them to the state and say to the state they're trying to deny the state taxes that the state is due. But the bottom line is, I also think it's improper for you to lose a commission on $150,000 just because they decide to do that when we all know the real purchase price is $1.1 million. So that's why we've included this sentence here, to hopefully protect you in terms of your commission. We've also added into this section, you'll see REC license ID. both for the listing firm and the listing agent, both for the participating firm and the participating agent. The new CFPB, Consumer Financial Protection Bureau regulations, specifically require the lender, and the lender is the one who's going to be preparing the closing documents now going forward, and is responsible for the closing. It specifically requires that they include in the closing documents, I believe it's on page 5, the real estate commission license number for the firm and for the contact person, the agent, on both sides of the transaction. The theory is that if there's a problem a year or 2 or 3 from now, it'll make it easier to locate find the firm if they've moved, their offices, to find the agent if maybe the agent has moved on to another broker. So this is now required information for the closing documents. We figured let's include it right up front, right here in the contract, so that the lender doesn't have to scramble to try to get this information to put together the closing documents. So we thought that made a lot of sense to just deal with it right now. And both of those ID numbers are on the real estate commission card that's issued, just so that you know.
Okay, a couple of questions, Barry. One is, how do we get the ID from the other agent?
You're going to have to ask from the other agent. Now, presumably, when the offer comes in, the buyer's agent is going to include this information right up front. That should be the standard practice. And then when the seller, reviews it before the seller signs, or when the seller signs, the listing agent firm ID number should be put in. That's the way it should work. So it should not be an issue.
Okay. One of the other questions had to deal with the fact that in the old contract, it used to have the language that said separate for the listing broker commission, and now it's included in the paragraph, the initial paragraph on paragraph 33, that it's included in the listing agreement.
Yeah, I don't know if that's really a change. I'd have to give that one some thought, because I don't remember that we even changed that. But the bottom line is that the commission's, it's there. The information is there that's necessary.
All right. And the listing firm, they're looking for not the broker's real estate license, it's the firm's ID.
That's correct. This issue came up again yesterday. I don't know, a question that somebody submitted in advance. And I said, just to be sure, I actually went on the Consumer Financial Protection Bureau's website last night just to confirm. It specifically says the brokerage firm.
Okay.
That's what they're looking for right there.
Is the commission paid on the total sales price, or if the buyer has a concession, is it based on minus the concession?
In my opinion, it is minus the concession. If there's a concession, let's say because a repair has to be made, and that's really what I'm thinking of in terms of concession, that would lower the purchase price, legitimately lower the purchase price. And as a result, I think that the commission should be based on the lowered purchase price.
Okay.
But having said that, if there's something in the listing agreement to the contrary, the listing agreement would govern the issue.
Okay. Where can I include the commission that is paid by the buyer?
Commission that's paid by the buyer. We did not include that here. If there's a buyer agency agreement and the buyer is going to be paying part of the commission, we didn't include something. That's a great point. Something that when the committee revisits a lot of the issues that have come up, we may revise it to add in something. But that's something it's a great point. There's nothing here, nowhere to put it in. I might just cross out where it says commission due participating firm down there. It's right in commission from buyer at this point, and fill in the amount on that line. Okay. Oh, also in this section, just for information, we added in just for convenience the office telephone, the fax, the agent's cell phone, email for both sides of the transaction for the agents, just to make life easier for everybody in terms of contacting the agents involved, contact information. Okay, moving over to section 34. We added this section in, disclosure that buyer or seller is a real estate licensee. We add this in because all too often I have to deal with the real estate commission sanctioning a broker or salesperson who did not include in the contract that the broker or salesperson is a buyer or seller or has an interest in the buyer or seller. It's required in Section 17 of the Licensing Act that you provide that information, that disclosure, to the other party. So we decided, let's just include it here. So that way it's applicable, it's not applicable. If it is applicable, then fill in the information. And that way it's a protection for you so that there's not going to be an issue involved. Next, 35. Brokers to receive closing disclosure documents. We added this in because of the new Consumer Financial Protection Board rules that went into effect. Under those rules, the closing documents are considered to be confidential, and it specifies that brokers are not going to receive it unless the buyer and seller agree that they're to receive those documents because it's confidential information. So we provided right here that they're agreeing that you will receive the documents in the same time and manner as the buyer and seller receive the documents, because it makes sense for you to get the documents. If you see something that's wrong in those documents, and as I mentioned before, those documents have to be in the hands of the consumer at least 3 business days before the closing. If you see something, you then can raise it, and it'll help the closing to go that much smoother. So we included that provision. Professional referrals in 36, we added this in. All too often there are lawsuits involved with regard to referrals that you may make. You give 3 names, and of course you're always going to give at least 3 names of a professional, whether it's an attorney, inspector, engineer, etc. And the buyer or seller then choose who they want to use. Well, all too often, if something goes wrong in what that professional does, the buyer or seller not only sue the professional, but they sue you for making what they call a negligent referral. So this provision says, hey, you know what? Buyer and seller understand that you're not recommending anybody. They're assuming responsibility for their selection. So hopefully this will be a good defense if there is any such lawsuit brought against you for making that kind of a referral. The next section, attorney review, we did not change. We're not allowed to change the attorney review language. Notices. Those of you who read the old contract recently will know that the old contract required any notices under the old sales contract, that Form 118, had to be sent by certified mail, fax, or telegram. I don't know how many of you have used Telegram recently. I haven't used it in a long time. In fact, I don't know if I've ever used Telegram. But the bottom line is, it made no sense. Everybody now uses email, overnight courier, now electronic signatures. So we deleted Telegram, and we added email, recognized overnight courier, or electronic signatures, except the notices under the attorney review clause section, because those notices are governed by the Supreme Court's language. So you can see right up above, notice of disapproval, where it says by certified mail, telegram, or delivering it personally. Those are really the only 3 ways that the notice of disapproval can be sent under attorney review. That's why we made an exception for attorney review, because we can't change the language that's in attorney review. Okay.
Is Saturday included in the days?
Oh, good question. Here's where there's going to be a little bit of confusion at least in the near future. We've all historically lived with the attorney review clause. And under the attorney review clause, it says counting the time. You count the 3 days from the date of delivery of the signed contract to the buyer and seller. You do not count Saturdays, Sundays, or legal holidays. Okay? You only count business days. So that's attorney review. That's what we're used to. And it still is a business day for attorney review. But here's the glitch. Under the new Consumer Financial Protection Bureau rules that went into effect on October 3, business days include Saturdays unless the lender is not open for business on a Saturday. You know, how do you know if a lender is open for business? I'm not quite sure, but that's what the rule says. So when you're counting business days under the new rules, and only for purposes of the new rules, you count Saturday as a business day. And so the only days that you do not count are Sundays or legal holidays. And I will tell you, legal holidays under the CFPB rules are federal holidays. So if there's a state holiday, that wouldn't be included. So it's a little bit different in terms of business days, and I know that's going to create a little bit of confusion going forward, but hopefully you have it straight now.
What is the, with reference to the receiving of the disclosure documents, the closing documents, what is the broker liability with regards to the privacy rules and secured emails that are included in the CFPB rules?
Well, any documents, I don't care if it's a contract, I don't care if it has any kind of personal information in it. There's responsibility to keep it confidential. So they're treated the same as any other documents that contain any type of confidential information, as I said, including the contract itself.
Okay. Why wasn't an acknowledgement of attorney review completion date added to the contract to make it clearer?
Well, because one never knows when the attorney review is going to be completed, and that's really the problem. Because the attorneys can agree between themselves to actually extend the attorney review period if they want to. So the only certainty we have is that it will end in 3 business days. If the contract will end in 3 business days, will become effective in 3 business days if it is not disapproved. If it's disapproved, it might end before 3 business days. If it's extended, it can be extended for however long the attorney is extended. So there was really no way to include a date certain beyond what's already in there.
Okay. Are the sections of the contract, such as referrals, closing doc distributions, etc., which might become points of contention in attorney review, reasons to disapprove the contract?
Well, the contract can be disapproved by an attorney for any reason or no reason at all. So you might have individual attorneys who don't like some of the new provisions, who didn't like some of the old provisions, and disapprove the contract, subject to agreement on those provisions. So I don't think there's anything that's going to be different in that regard in terms of attorneys looking to disapprove anything that they're not comfortable with.
Okay.
Okay. Then moving along, Section 40, electronic signatures and documents. Just want to point out that we added in this section really to state what the law is, because we've had too many situations where attorneys say, no, I'm not going to accept electronic signatures. I want a wet signature, an original signature for certain documents. Not required. Under federal law, under state law, the electronic signature and documents acts specifically include real estate transactions. So electronic documents are allowed. And so we just wanted to kind of state that so there would not be any question. We also added in a statement with regard to witnessing the signatures of the buyer and seller. On the last page of the contract, as you all recall, there's a witness line next to the buyer and seller signatures. But we have an electronic signature, you don't have a witness there, and that's okay. Because under the acts, the federal and state acts, it specifically says, as long as the signature has been properly verified, which is done when you use like Form Simplicity and some of these other document companies online, you don't have to have a witness for those signatures. So that's a question that comes up fairly often. So we wanted to just include it here so everybody's on the same page. Then finally, 41, corporate resolutions. We just added a statement that if the buyer or seller is a corporation, that all proper resolutions have been passed and that the person who's signing is authorized to sign. That's one of those provisions that's pretty standard in a contract. We felt it was appropriate to add it in. And those are the major changes. Once again, I encourage you, go back, read the entire contract now in light of the major changes, but read every section, because I suspect that even the sections that did not change at all, you'll pick up additional things in those sections that you don't even remember from the last time you read the contract. Now, one other thing I do want to mention is that the New Jersey Realtors also has posted a timeline that is tied to all of the times that things must get done under the new statewide contract. The new timeline is not mandatory, just like the statewide contract is not mandatory, although we believe that you really should use the statewide contract. It's the most up-to-date contract that's out there as far as I'm concerned. It includes, all the protections and bells and whistles that you would want in a contract. This will give you an idea, because every single place in the new statewide contract where there's something that must be done by a time certain, we've included here. So you now can fill in the dates and keep track of what has to happen. I don't care if an attorney is responsible for doing it, or a title company is responsible for doing it, or you're responsible for doing it. It's just a great way to have a checklist, we thought. And it also references the section in the contract that it comes from, so you can go back and look at the contract and get the exact wording. So the different areas that we've covered: dates for attorney review, deposits, the condominium homeowner association information, leases have to be provided, lead-based paint notice, and of course, all of these are if applicable. Private wells, cesspools, radon, inspections, flood hazard area, mortgage contingency, buyer's property sale contingency, title exceptions, walkthroughs, closing documents, and closing. Now, going through this list, which I'll tell you, it's a real good list, because I just saw 2 items that I did not mention when I was going through the sales contract that I want to go back to mention. Flood hazard area. The section of the contract dealing with flood hazard area, I for some reason went right by it. It's on page 9. Just to point out, the addendum that many of you were using in terms of flood hazard insurance now has been incorporated right into section F. There it is, that second paragraph, being a buyer's mortgage lender may require a buyer to purchase flood insurance. That was an addendum. We have now added it right into the contract, so you don't need to use that addendum. And I just wanted to point that out. I went right by it. The other thing that I did not mention, and I'm so glad there was a checklist there, is section 28 on page 11 of the sales contract. Initial and final walkthroughs. There actually were some questions that were submitted yesterday on this issue. Because of the new Consumer Financial Protection Bureau regulations that went into effect on October 3, that require the lender to get the consumer the closing documents at least 3 business days before the closing. And if it's sent by mail, you have to allow 3 business days for mailing it. So that's then at least 6 business days, and lenders are saying they're probably going to send it out 7 or 8 business days ahead of time if they use the mail. I am encouraging you to have an initial walkthrough 10 days before the closing is scheduled to see whether or not there is any issue, so that if there is an issue, there needs to be some type of adjustment. Those numbers can be worked out. The numbers can get to the lender in a timely fashion, so when the lender does the closing documents, it's already taken care of. You don't have to scramble at the closing. Now, I also encourage that you do a final walkthrough the morning of the closing, just like you do now, just to make sure that there's nothing major that has happened, like a tree hasn't fallen on the house and destroyed the roof or something along those lines. But that, I'm now encouraging 2 walkthroughs. I know it's a little bit of extra work, but I think that it's prudent to do that. And so we've included a section right here in the contract that allows the buyer to do the 2 walkthroughs in addition to other inspections that are set forth in the contract. This is another one that is really necessitated by the new Consumer Financial Protection Bureau regulations that went into effect. So that's about all that I have in terms of the contracts. I don't know, Christian, you have anything else you want to add?
I have a couple of questions. Okay. Somebody asked if can anybody refuse to accept the e-signatures, like can a company or somebody refuse to accept any signature?
The answer is that they can refuse to accept them, but they're, the federal and state law says that they are to be used, the same as an original signature. But yes, they can make that decision. In the modern age, though, that's pretty anachronistic as far as I'm concerned.
Okay. I'm looking to see if we have any additional questions. And they're coming through. While I'm waiting for the questions to come through, I'd like to point out that Barry will be doing 4 seminars at our Triple Play Convention in Atlantic City, 2 on December 8th at 10 and 1 p.m., and 2 on December 9th at 11 a.m. and 2 p.m. And that'll be in addition to his legal update, which is Thursday at 10 a.m. as well.
So I just would encourage you, if any of you, want to do this live, have questions at that point that you want to ask me. It'll be very interactive, all those seminars. So I'd encourage you to attend it. After using the contract, you have additional questions that haven't been answered today.
Okay. In reference to the header in the statewide contract, which contract can we use if we make an offer on a FSBO?
You can use either contract. The old Form 118 is good for a FSBO. The new statewide contract is fine for a FSBO.
All right, thank you. On line 135, what if there are 3 home sale contingencies to buy? Does all delay, or does this contract only take into effect the first 2 home sale contingencies?
Well, we've only provided for the 2, but you can add in if there's a 3rd home sale contingency that needs to be added. You can add it, just add that in.
All right. What about multiple contract offers on a property with an HOA enlarged document?
I'm not sure what you mean by HOA enlarged document, but but there's nothing under this contract that would change the process when there are multiple offers on any property. I don't care whether it's an HOA property or not.
Okay. I was told time of the essence is not to be in short sale. Can you please clarify?
If there may be lender conditions that are imposed that may change time of the essence, and that's part of the agreement that has to be reached if it's a short sale. So you're going to be using the short sale addendum to deal with that. And as I mentioned at the beginning, the short sale addendum has been amended to deal with that issue.
Okay. In section 34, if I submit an offer and indicate the buyer is not a realtor, do I complete section 34 or do I let the seller's agent complete it first?
Would you read that question again?
I think what they're trying to get at is in section 34, it talks about.
Right, that's the disclosure that the buyer or seller is a real estate licensee.
Right, correct. But there's no place actually. Is it supposed to be completed by the buyer on this particular, or the buyer's agent on this particular side, where the seller should have disclosed it prior to them even putting the offer in?
Oh, I see what I understand the question now. Yeah, the bottom line is that if the buyer is a real estate licensee, or the real estate licensee has an interest in the buyer, that should be filled out there. Now, there could be a situation where both the seller's agent and the buyer's agent are licensees. In that situation, we really didn't include a space for both of them to fill in. So I would say the listing agent should write it in where it says other contractual provisions, in the same way that's done now.
And that paragraph should be just for the buyer's agent to fill out for the buyer.
Well, this would be both, but it's very unusual that both the buyer's agent and the seller's agent are going to be real estate licensees. So the only time this wouldn't be used would be, or that it isn't satisfactory, if you will, is where both of them are licensees. And so you'd have the buyer's agent fill out that section, and then the seller's agent, the listing agent, would just fill out the same identical provision and put it in additional contract provisions. So that way they both would be disclosing it.
All right. Also in section 34, what about the disclosure of an agent being related to the buyer or the seller?
Actually, section 17 does not require that, section 17 of the Licensing Act. I think it's prudent to include it. But it's not required by law, so we didn't include it here. I just think any time that you are representing a relative, whether it be a brother, a parent, a cousin, better to disclose that to everybody up front, but it's not required, and therefore we didn't include it.
Okay. In reference to attorney review, do you count the date of delivery as the first day of attorney review, or does it start the day after? So if I bring you everybody has a contract at 3 o'clock in the afternoon on a Wednesday, does that the first day of attorney review? Does it start on Thursday?
Okay. I don't want to go into attorney review seminar, but you start counting the next day. You don't count Wednesday. So Thursday is the first day, Friday is the second day. You don't count Saturday. You don't count Sunday under attorney review. If Monday is Labor Day, you don't count Monday. Tuesday is the third business day.
All right, there's a question here that says, when talking about inspections, does the inspection have to be done by a licensed inspector or can a contractor do it?
Well, I believe that it says licensed inspector, but I'd have to go back and double check the language.
It did previously say that. I don't know if we somehow are missing it from here, but
Yeah, I'd have to look at the language. I don't remember specifically, which is in there.
Okay. That seems to be the end of our questions.
I'd like to thank you all for joining in this webinar. I hope that you've learned something, and I hope that now you'll feel comfortable using the new statewide sales contract. And I look forward to seeing you all at the convention, if any of you want to come to one of those seminars.
Thank you again for everybody for listening in.